In the English law of homicide, manslaughter is a less serious offence than murder, the differential being between levels of fault based on the mens rea or by reason of a partial defence. In England and Wales, a common practice is to prefer a charge of murder, with the judge or defence able to introduce manslaughter as an option. The jury then decides whether the defendant is guilty or not guilty of either murder or manslaughter. On conviction for manslaughter, sentencing is at the judge's discretion, whereas a sentence of life imprisonment is mandatory on conviction for murder. Manslaughter may be either voluntary or involuntary, depending on whether the accused has the required mens rea for murder. Voluntary manslaughter occurs when the defendant kills with mens rea, but one of those partial defenses which reduce murder to manslaughter applies. The original mitigating factors were provocation and chance medley, which existed at common law. But the former has been abolished by statute. The latter has been held no longer to exist and new defenses have been created by statute. The Homicide Act 1957 now provides two defenses which may be raised to allow the court to find the accused guilty of voluntary manslaughter, diminished responsibility and suicide pact. The Coroners and Justice Act 2009 creates the defense of loss of control. Under Section 2 of the Homicide Act 1957, there are three requirements for the defendant to raise. The defense of diminished responsibility. The defendant must have suffered from an abnormality of mind at the time of the killing caused by one of the causes specified by the Act which substantially impaired the defendant's mental responsibility for the killing. Under Section 2 of the Act, it is for the defendant to prove he suffered from such a condition on the balance of probabilities. An abnormality of mind has been defined by Lord Parker C.J. as state of mind so different from that of ordinary human beings that the reasonable man would term it abnormal. In deciding whether this state of mind exists, the jury should consider medical evidence, but also all other evidence including acts and statements of the accused and his demeanor. The jury does not have to accept the medical evidence if other material conflicts with an outweighs it. The Homicide Act specifies three causes, one of which must cause the abnormality. They are a condition of arrested or retarded development of mind, any inherent cause or a disease or injury. Whether the abnormality is caused by one of the specified causes is a matter for medical evidence alone. Alcoholism is capable of being an abnormality of mind even if there is no physical damage to the brain. Whether the abnormality substantially impaired the defendant's mental responsibility for the killing is a question of degree for the jury. In R. V. Lloyd, the Court of Appeal held that the lack of control must simply be more than trivial. Premenstrual tension has been accepted as a mitigating factor in several high-profile cases. In 1980, Sandy Smith was convicted of manslaughter for stabbing a barmaid. Dr. Katharina Dalton, who examined Smith before the trial, diagnosed her with severe PMS. This diagnosis was accepted as a cause of diminished responsibility. Smith was sentenced to 3 years probation despite previous convictions for violent behavior. See loss of control. It is a defense to murder, if accepted or plea bargained, resulting in manslaughter by reason of loss of control. Section 4 of the Homicide Act 1957 introduced the defense of suicide pact. Parliament's intention was to show some compassion for those who had been involved in a suicide pact but failed to die. Section 4 defines a suicide pact as a common agreement between two or more persons having for its object the death of all of them, whether or not each is to take his own life. Further, the accused must have had a settled intention of dying in pursuance of the pact, to avoid the accused entering into a supposed pact with the real intention of committing murder. The Law Commission has proposed abolishing the defense with deserving cases falling within diminished responsibility, but feels it should be retained pending a review of a new partial defense of mercy killings. Involuntary manslaughter arises where the accused did not intend to cause death or serious injury, but caused the death of another through recklessness or criminal negligence. For these purposes, recklessness is defined as a blatant disregard for the dangers of a particular situation. An example of this would be dropping a brick off a bridge, landing on a person's head, killing them. Since the intent is not to kill the victim, but simply to drop the brick, the mens rea required for murder does not exist because the act is not aimed at any one person. But if in dropping the brick, there is a good chance of injuring someone, The person who drops it will be reckless. This form of manslaughter is also termed unlawful act or